So a very, very warm good afternoon. We are very grateful to Mr. V.K. Gupta, who has been the Honorable NCLT technical member of not only the Kolkata bench, where I've had the opportunity to really see how diligently and how from the front he used to take forward all the hearings diligently, very, very diligently, in fact, in the NCLT Kolkata bench. Then we also witnessed how beautifully, without any effort, he got really mingled well with the Allahabad bench and in the Ahmedabad bench. Both the benches as the NCLT technical member. V.K. Gupta ji's most important USP, which we have seen as lawyers, is his fastness of grasping things. And in spite of having maybe 1,000 papers on his table, he always used to ask the right question. I don't know how. We always used to wonder that if we are going in front of Gupta ji, we will not be able to save ourselves. He, in spite of all that we do, he'll just ask the right question. So I think he's very fortunate to have that kind of blessing with him. I'm sure God is extremely kind to him. It doesn't happen without God's blessings. I must also say that on his table, we seldom used to see anything pending. He always used to believe in giving very fast and good orders. I remember reading somewhere that his 98 to 99%, I know it's quite a sparkling figure and also startling figure, has been, even when it has gone to appeal, 98 to 99% matters have come back as it is. So it's a matter of great pride for IBC Laws, and on behalf of IBC Laws here and the All India Insolvency Professionals Association, that is AIIPA, and also on behalf of the NCLT Kolkata Bar Association, we have today Mr. Onkar Gurjar from IBC Laws. He's the CEO and also the promoter developer of IBC Laws. I'm also one of the consultants with IBC Laws, and I also take a lot of pride in being there with IBC Laws, apart from being the country's first insolvency professional and taking pride in appearing before the NCLTs. We have a very senior professional, Shri S.M. Gupta, who's the president of the NCLT Kolkata Bar Association. His age actually defies him. He's so active. Gupta ji, would you like to say a few words and then we can actually begin?
Yeah. Thank you, Mamta.
Yes.
I don't know whether my age defies or not, but I try to really do my work. Come what may, every day I do my work. So, on behalf of NCLT Kolkata Bar Association, we welcome Justice V.K. Gupta ji, who is a well-wisher to Calcutta bench of NCLT than anything else. When he was here, we used to meet him frequently on behalf of the bar, and he was very cordial and very nice to us and to the whole bar. And in fact, the whole bench was benefited by his presence. Thank you, Gupta ji, for coming and blessing us. And other participants also, we welcome everyone of you, because without whose participation this meeting would not have been successful. So we welcome everyone. Thank you, Mamta. Over to you.
Thank you. To all my esteemed participants here, thank you for joining in good numbers. Sometimes it is said that numbers are not important, but when we have dignitaries like Shri V.K. Gupta ji, it really becomes pertinent that his time is well spent, well spread, and his words of wisdom is well benefited by a lot of us. So today, sirs, we have more than 100 participants who are here to listen to you, Gupta ji. In absentia though, but it's important as we are heading the NCLT Kolkata Bar Association, we must say that we are very delighted to have two excellent benches in the NCLT Kolkata bench now. The benches are really hearing us and really delivering justice. Sitting in the temple of justice, delivering justice in the real sense is not an easy task. I'm also joined by our one more participating organization, that is the All India Insolvency Professionals Association. And we have a very renowned chartered accountant who's heading that professionals association, Shri Anand, who himself is a repertoire of energy. If I cannot find a good word, more a better word, I must say that he's full of energy and he's full of that concept of really thinking as Vasudevam Kutumbakam. He really follows that not only in letter but in spirit. So, Mr. Manoj Anand, you may like to speak something and then we'll begin the program.
Yeah, thank you, Mamta ji. You being my elder sister, guide, friend, and philosopher also. And as far as Mr. Gupta is concerned, you already have very heavy for him. We are really blessed that he's sparing some time for this webinar, and we love to listen him. We love to understand from his mouth that what Section 14 moratorium says. Moratorium mean in Hindi roke, but it is not a roke. He will enlighten us with more things, and without taking much time and without wasting any more time on it. I would love to listen to Gupta ji. Welcome to Gupta ji. Thank you very much. Thanks for inviting me for kind words. Thank you very much.
Gupta ji, we would like to really understand the nuances of moratorium. Why we've written in the card as the so-called moratorium, as Mr. Anand was also pointing out, that yes, it is called the roke, it is called the calm period, the peace period, the period where nothing else comes to the front of the CD and they entirely concentrate on resurrecting and rehabilitation and restitution of the corporate debtor. That's the whole concept, that as if because the corporate debtor is in ICU and is in the hospital bed fighting for its life, so all the energies of the doctors should go in saving the company and not in anything else. That's the concept that we understand from the calm period and the moratorium. I'll take the liberty to pitch in wherever you deem it appropriate.
That would be a great assistance. That would be a great assistance to me, to all participants. At the very outset, I feel really humbled with the kind words which have been spoken about me. But Mamta ji is hit the nail by saying that I am divinely blessed, and that is a fact. I am told in Bhagavad Gita, Bhagavan Krishna has said that he is the cause of all causes. He is the cause of memory. He is the cause of loss of memory. So once you feel that you are not a doer, you are a means, then you automatically get that energy, vibes, and assistance. And that has been a special characteristic of blessing in my life. So I'm really privileged from all corners, blessings of elders, and the assistance given by you learned chartered accountants, advocates, and other participants of the proceedings in the benches. So with these words, I would like to come to the topic straight away. The title is the so-called calm period. So before the this session started, I was interacting with Mamta ji. What is your intent behind, or the IBC's intent behind giving this title, the so-called calm? Because moratorium has not been defined in the IBC or in the acts where we can borrow from the definition, such as recovery of debts due to the banks and financial Institutions Act 1993 or Companies Act 2017, as mentioned in Section 3, subsection 37 of IBC, in case a term is not defined. So we can go that. So coming back to that the so-called calm period has got two aspects. The title. One title is from the perspective of the corporate debtor, whether it is really in effect followed by the authorities or the forums or other contractual parties where the object of moratorium is obtained. But it has got another aspect. Somewhere the scope of moratorium has been expanded. though not explicit there, not provided there, and the Supreme Court had to intervene. First, in the case of embassy properties development, that is by virtue of what jurisdiction the adjudicating authority can derive under Section 60, subsection 5, clause C. So, whatever in by this, what I mean is that the moratorium is not absolute. Apart from moratorium, there are certain provisions which also give jurisdiction, though as we know that the interpretation is restricted to the express provisions or the intent. As a holistic view has to be taken of structure and scheme of any statute, be it IBC, be it any other. So in that sense, what is happening, it is a creator-centric. And for the creator, rather to be more specific, it is a financial creator-centric regime, because operational creator's fate is known to the world. So what is happening in that process to make it the moratorium has though the authorities, but it is somewhat somewhere is not just to the contractual counterparties who are forced to supply or provide services because of provisions of Section 14.2 or 14.2A, and some provisions take care of cost if there are financial creditors and the committee of creditors is comprised thereof, the funds are not an issue, but even though they may not be sure of getting payment, so in spite of supplying, though the provisions say, we will discuss in detail. So the so-called calm period, in this sense, in my view, has got both the connotations. One from the perspective of the corporate debtor and other from the perspective of the contractual counterparties. And we have to find a balance, and balance is being developed somewhere, some protection is given. So now this is the basic background. Moratorium, it traces its statutory origin from Section 446 of the Companies Act 1956. Therein also it was not defined. So moratorium originates from a Latin word that is moratorius, which denotes some delaying of servicing of financial obligations and suspension of certain performance of certain obligations during a temporary period. This is the definition. And one more thing, the moratorium as such is not specifically defined, nor the objects which it seeks to achieve are defined. But that you have to, for that you have to go back to the preamble of the IBC and the nature of proceedings being in RAM and for the benefit of all stakeholders. So that is another part. If moratorium has to be considered. Now, for this purpose, it encompasses within itself the orderly conduct of CIRP, one of the object. The multiplicity of proceedings should be avoided. Another thing is that the corporate debtor is able to run as a going concern. Another laudable and more pertinent object is consequently resulting into the maximization of the value of assets, in addition to protection and preservation of the value of the assets of the corporate debtor. So this is the object. These are the objects for which the concept of moratorium has been statutorily recognized under IBC. The provision starts from Section 13. Section 13(1)(a) specifically says that when an order of admission is passed, the adjudicating authority declare a moratorium for the purposes of matter referred, for the purposes, not of matter, purposes of matter nahi likha hai, purposes referred to in Section 40. So this is the initiating point. When the moment a corporate debtor is admitted into CIRP under section as a consequence of an application filed under section 7, 9 or 10, the moratorium comes into effect by virtue of an order passed by the adjudicating authority. And it is for the purposes referred to in section 14. So section 15, before we go to section 15, 1F, the public announcement says that it will also mention when the moratorium will, CIRP will come to close. Section 15, 1F. The date of CIRP shall close. This is because the moratorium ceases to affect on completion of CIRP. So that is also that means it is for now we come to section 14 subclause 4, subsection 4. This also says on completion of CIRP, it shall cease to have effect. Read with the proviso there. We will come to on those clauses specifically. So it is for a temporary period aligned with the timelines provided for the resolution of insolvency or bankruptcy of a corporate debtor. Coming after, when we come into this condition, so immediately a question, though it is a section 14 we are covering only, but the question comes, what about the interim moratorium? Because initiation date is something that different. That is the application filed under section 7, 9 or 10. That is the initiation. And insolvency commencement date is different. That is the date on which the order of admission is passed. That is insolvency commencement date, as per the definitions given in the relevant sections. So, why can there be a situation in law? Because there have been a few judicial decisions where the Nui Pulp and Paper and other two more decisions where the interim moratorium was granted before admission of application under section 7, 9 or 10. Whether the adjudicating authority is competent to have a recourse to Rule 11 of NCLT rules. Once section 13 is very clear when we are going to declare. Read with section 14, one main part. Unlike section 96, where interim moratorium is provided. So, this is a question which has to be seen. If there is no provision for interim moratorium in case of section 7, 9 or 10 applications in chapter 2 or part 2 as such. But having regard to the purposes, if some views have been taken earlier but not now, and the reason for this, now there can be both sides of this aspect, because if the assets there is a delay in admission of the application under section 14 in spite of a specific provision covered under section 64(1) for expeditious disposal of applications filed under section 7, 9 or 10, or section 7, 9 or 10 itself provide that within 14 days or within 7 days what we have to do. So due to delay, whether the corporate debtor or a mala-fide management can be allowed to siphon off the assets, to strip off the assets of the corporate debtor, but to what? So there is a gap. So to fill the gap, can we resort to section 11? Generally not, because section 11 can come into play only when there is a gap which is not covered by the express provisions of law, or any residuary provision can come into play. So that way, my view is that section 11, rule 11 of NCLT rules can be taken into consideration, but where there are apparent facts or circumstances which justify and nobody can challenge that, then only it can be applied. Otherwise, as a matter of practice, interim moratorium cannot be applied under section 14 or 13 or whatever it is there, because the express provisions of law state very clearly at what stage it will come into operation and in what manner it will be played out. Now coming to section and one more thing on this aspect is there are enough provisions also if there is a siphoning off, so that preferential, undervalued, or transactions are there, penalties are there for violation of moratorium. So those provisions also support the case that there should not be imposed any interim moratorium unless the glaring circumstances exist. Now coming to the, before we go to the section 14, 1, 2, 2A and 3, we have to see the aspect of, since it is period is important. If section 14(4) provides that shall affect from the date of such order which refers to section 14(1). 14(1) also refers to order of adjudicating authority, though section 13(1)A also refers to the order of the authority. It is a duplication. 13(1)A and 14(1) have got the same fact, same aspect covering in between. The adjudicating authority has to declare moratorium. So at two places. So 14(4) refers to the order passed under section 14, subsection 1. So on the with effect from the date of such order till the completion of CIRP process. The words are completion of CIRP process. But the except CIRP itself has not been defined except in Rule 2 small e of CIRP regulations, which is simply state that the CIRP means the completion of the CIRP process and as envisaged in chapter 2 or part 2 of the IBC. So completion word is not, this aspect has not been very clearly defined when it can be said to have completed, though practically we know either passing on the order of the approval of resolution plan or in case the liquidation order is passed, the CIRP is generally is considered to have been completed for that purpose. And thereafter, in case of resolution plan being approved, the further proceedings will take in terms of the provisions contained in such resolution plan to take it forward till it is implemented fully in terms indicated there. So now this is also raised a few questions that the 14(4) proviso provides 31(1) or section 33 order as the culmination point of the termination point of the same thing is mentioned in section 31(3)(a). The moratorium shall cease to have effect from the passing of order under section 31(1). So in my view, this is again a duplication. 14 subsection 4 is the main provision governing section, governing provisions regarding moratorium. It also provides how it operates and to what extent and in what manner and to what period it will operate. So there is again, and that section 31(a), 1A, 31(3)(a) doesn't serve any purpose except the IRP or RP may be bound. So clause A, 3A is also superfluous in my view. Because same thing is taken care of by this proviso to section 14, subsection 4. So that is also a need to see sometimes different interpretations result because of one thing is contained at more than one places. So to avoid that, this is the one thing. So now completion of CIRP process is related with the CIRP period. CIRP period is generally we understand is 180 days as extended under section 12 of the IBC to the IBC 2016. So it 12(1), 12(2), and 12(3). So it raises, can there be a situation? That means the CIRP process is under 180 days have passed. Extension application has not been filed. Unless it is extended, the original CIRP period has passed. Whether the completion of CIRP has not happened, that is for, but how it will impact the moratorium? Can there be a situation of abeyance of section 14 in between, because section 23(1) proviso, after approval of the plan by COC till the approval of plan by the adjudicating authority, the RP is made responsible to manage the affairs of the corporate debtor. As we all know that CIRP has got two aspects. One is orderly conduct of process of resolution of insolvency, and to maintain, the other aspect is to maintain the status of the corporate debtor is a going concern. So in between, there is some situation may come where a new problem may arise. To avoid that, the RP must ensure that he gets the extension of CIRP period before the expiry of the CIRP period. Though adjudicating authority can pass an order with retrospective effect, but unnecessary litigation may result if somebody acts on this gap, in the gap period, when he says that there is no moratorium, because there is no order of extension of CIRP period. No order of liquidation has been passed. So this aspect we may further discuss, but there is an area of gray area which we need to avoid from that perspective. So section 14(4) we have covered. Now all the aspects related to this we have covered. Now we will come to the main provisions. That is section, we will first deliberate on 14(1) main provision, which is subject to subsection 2 and 3. But section 2A has been inserted thereafter in the main section. So whether it is not subject to subsection 2A, and if it is not so, what is the significance of these two words, subject to subsection, provisions of subsection 2 and 3? 3 is, of course, absolutely clear that it is an exception to the main provisions of moratorium. In the 14(3) provides the things where the moratorium, in that situation, the moratorium will not be applicable. But 14(2) and 2A, are they really exceptions which the main provision be subject to, or they are additional safeguards provided in this section 14 to give to safeguard the interest of the corporate debtor and other stock stakeholders. So that is one thing. Something is need to be looked into, because in my view, subsection 2 and subsection 2A are additional safeguards in addition to the general moratorium contained in clause A to D of subsection 14(1). The objects of those provisions, each clause is different, but similarly, the object of these two clauses, subsections, are also different. So that is one aspect, but though it is does not make any material impact on the operability of this section. So this is just a thing that the casual drafting approach is taken sometimes, and the amendments are not taken to the logical end. So that is the only thing which I wish to highlight. Now comes the section, clause A of subsection 1. Clause A of the subsection 1 says that prohibiting all of the following. So all the four are prohibited. And subclause is the institution of suits or continuation of pending suits or proceedings against the corporate debtor. That is of critical importance. It differentiates in that sense section with section 33 subsection 5 of chapter 3 of part 2. Again, including execution of any judgment, decree or order in any court of law, tribunal, arbitration panel, or other authority. So these are, so first of all, subsection 1 is that there are two words, suits or proceedings. Proceedings, the word proceeding has been a subject of interpretation. Firstly, in the case of P. Mohan Raj, where it was Section 138 of Negotiable Instrument Acts, proceedings thereunder would be covered within the moratorium or not, and what is whether criminal proceedings will be covered or not. That is one thing. And thereafter, in the Honorable Supreme Court analyzed the provisions of law in great detail, and thereafter came to conclusion that even the proceedings under Section 138 of NI would be covered under moratorium, because ultimately, if the liability to pay crystallizes, it will deplete the assets and value of the corporate debtor. On that, it was not an open-ended that every criminal proceeding will be covered under Section 14. But if it results into some depletion or going concern status, then only it will be covered. So that was one thing. Thereafter, in the case of Power Grid Corporation, where there were certain arbitration proceedings, some tax proceedings were there, or then it was defined that it doesn't cover all proceedings. Proceedings is the word proceedings is not prefixed by the word all. So there could be a proceedings which can be still carried on or taken to the logical end. And but to up to what stage, that we will cover up. When first of these things came into embassy properties, which resulted into incorporation of provision of explanation to Section 14(1) as well as 14(2)(a). Both the provisions based upon the ILC report of February 2020 were given effect retrospectively from 28 December 2019. So the question comes here that key proceedings word has come into interpret. The Delhi High Court in the case of Power Grid also held that including, importance of including, and on that basis, it was propounded for the first time perhaps that a purposive construction of this provision is required. Unless the object sought by the moratorium are going to be hit adversely to the corporate debtor, the proceedings can continue. For example, arbitration can be finalized, but the moment award is passed, it cannot be decreed. Then the 14(1)(a) will come into play. For example, income tax assessment proceedings may continue. It was also held in embassy property. But the moment a demand is raised, that becomes an operational debt, and the department has to file the claim. The jurisdiction of the income tax authority will come. Then, but otherwise, the adjudicating authority cannot usurp the jurisdiction of income tax authority or arbitral tribunal. The moment it becomes a case, an instance of operational debt or question of law, priorities, or any issue arising out of or in relation to insolvency resolution or liquidation proceeding, then you can assume the jurisdiction. Similarly, the provision of moratorium will come into effect at, you can say, pre-award stage, post-award stage, and recovery stage. If every proceeding, whether tax proceeding under Income Tax Act or GST or customs, excise, customs, so or any other law, if it is going on, can it be stopped? This question has also been answered by Honorable Supreme Court in Sundresh Bhatt, where they had you can continue with the proceedings, but you cannot execute the award. So more or less, this thing is settled now with the highest court of law saying this. Proceedings can continue, but still we generally the tribunals and the other forums follow this as a literal interpretation of this. Everything is to be stopped, and there is a logic also. If it is not stopped, there may be problems also, which we will discuss further, which arise if it is to be allowed. But if it That means ki in effect, Section 238 not coming into operation, there is no provision in the IBC which is to prevail over the provisions of computation, assessment, everything. And in fact, IRP and RP are duty bound to comply with the law. If we go section 17, 18, 20, 23, 25, we go, so there are rather they have to comply not only with the authorities, but they have to also participate in quasi-judicial proceedings, arbitration proceedings. That taken together, it indicates that all proceedings as such are not banned or prohibited. They are prohibited till the stage of recovery, execution. That is what my understanding is. That is my understanding is. So in this connection, against the corporate debtor word is very important. Ki against the that means ki it gives a freedom to the corporate debtor to pursue any proceedings, which is not the case in 33(5), because RP has to take approval of the liquidator has to take approval of adjudicating authority. There, even in section 446, approval, or 279 of the Companies Act 2013, approval of the binding up court or tribunal is required in certain proceedings. So it cannot happen ki on one side it raises you allow the corporate debtor to continue with the proceedings which are in favor, and which are against all those proceedings are stopped. So this issue raises a question of equitable treatment, fairness. But as we know that generally fairness or equity is stranger to the IBC. But it's not so, because otherwise the sanctity of the commercial contracts, which is well established beyond the insolvency regime, is suffering a great lot. So suppose what happens now, there is a peculiar situation which may happen. 2-3 instances we can discuss in arbitration proceedings. Corporate debtor had filed before CIRP is initiation, insolvency commencement, or during there is no bar. RP files on behalf of the corporate debtor any proceeding for recovery of the debts due to the corporate debtor. In that process, the other party, the respondent or defense, files counterclaim. What would happen to that? The judicial view is very settled. The counterclaim, as such, can it be? Had there been an independent case of a separate proceedings by the other party, by filing a claim against the corporate debtor as a claim, not a counterclaim, that would have been prohibited. So what happens in SSMP Industries, Delhi High Court, in Jharkhand Bijli Vitran Nigam Limited, what they say, the proceedings filed by the corporate debtor will be maintained, and the counterclaim can be adjudicated as it is both are intertwined, interconnected. Both the things are several proceedings has to go. If suppose Delhi High Court has held that the counterclaim is less than the amount of claim, that can be pursued. The net liability, net money comes to the corporate debtor, which in my view is not correct, because ultimately depletes the assets to the extent of counterclaim as per the strict interpretation of law. But they have held so. So what is that? Ki counterclaim cannot be pursued, and it cannot be counterclaim cannot neither be pursued nor it award can be given in favor of the corresponding counterparty to the same proceedings. What happens in the resolution? There can be another situation in this situation. In this case, a resolution plan is approved, and resolution plan is approved and implemented. Resolution provides that all claims, whether existing, contingent, of filed or not filed, matured or unmatured judgment or decree shall stand extinguished. So all counterclaim goes. But the corporate debtor under the new management still wants to pursue the arbitration proceedings which were not pursued or not culminated during the continuation of CIRP process. So whether in this situation, though the resolution plan has stated that shall stand extinguished, to that extent there is no difficulty. But the moment you continue with the proceedings, can the counterparty be allowed to file a fresh claim, counterclaim, or the same claim as a fresh claim, counterclaim? Because the proceedings of arbitration are initiated by the corporate debtor under the new management or continued from where these were left. So this is a question which needs answer, but going by the view of the Honorable Supreme Court in SR Steel and Ghanshyam Mishra, Section 60, subsection 6 also doesn't rescue the corporate, the counterparties, because clean slate theory has been given. So if that, but one has to see from the perspective of, because in resolving an insolvency of one particular corporate debtor, we should not enter into a situation we create so many other corporate debtors going under insolvency resolution. They are compelled to go, because there are situations where there is a chain effect of insolvency, the proceedings being in RAM, and Section 31(1) is binding on everyone. Though you have participated or not, likha participated, but the moment it is done, advertisement is done, or email now is sent, or you are aware otherwise, or not aware, but you are nowhere whether actual participation is not required. Participation means that has not been defined in that sense, but it is assumed that all liabilities stand extinguished with that. So this is an area, arbitration against the corporate debtor. As such, the earlier view was that it cannot be initiated because it is clearly covered. But in some cases, the court have deviated from that norm. It can, up to an extent, pre-recovery stage, till the determination, it can proceed with. The moment it is determined, the party has to file a claim in terms of provisions of IBC, but that will also create a problem, because if the specified period of 90 days has passed or the resolution plan has been approved, so that claim itself becomes infructuous for all practical purposes. So that some provision is to be made in law. Valid claims, if it should be a cost of resolution, the new management must be made to aware that it is not the case. Clean slate doesn't mean you wash away the hands from the genuine liabilities of other parties and made them to suffer by a statutory provision of law. It is totally, in my view, it is a violation of constitutional provision of Article 19(1)(g) read with Article 14. Freedom to trade, it strikes my freedom. The law which is being made, it is violative of fundamental rights, but nobody has challenged. The Honorable Supreme Court has 19(1)(g) or 14 on some other issues. There has been challenged, but as a whole, on these grounds, you take away the rights of the other person to carry on the business. One can understand if there is a provision of commercial arrangement, one is not repeating, but whatever both the parties may decide to forego or to readjust their amount of claims. But can a statute take these rights straight away without giving any opportunity and forcing one to go into insolvency or wind up its business? So Article 21, right to life, also may be invoked in some cases if somebody invokes. It's a question of my life and death for operational creditors in particular, because their margin of profit, their dues may be 50 lakhs, but their margin will be only 5 lakhs, 2 lakhs, 3 lakhs, 4 lakhs. So for 4 lakhs, 50 lakhs is gone. And that 50 lakhs, there may be a creditor behind them There may be a creditor behind them. So that is having a chain effect and a multiple. That is why the MSME sector is suffering. In the economy, there is a boom, but at the cost of MSME sector. And this is also resulting into working against the preamble to make availability of the credit. Who will give the credit? So these are the issues emanating from moratorium and the inter-twin treatment of the claims. So that is 14(1)(a). That is what I think we have counter claims covered. Now we will come to section 14(1)(b). We will have to go to 1B. Transferring, encumbering, alienating, or disposing of by the corporate debtor any of the assets, any of its assets, or any legal right or beneficial interest therein. Now this word is corporate debtor, and it is further emphasize its assets. So the question, by the corporate debtor of its assets, so whether on whom it is applicable, this restriction, this moratorium provision of transferring, encumbering, alienating, or disposing of by the corporate debtor any of its assets or any legal right or beneficial interest. Three things have been covered: its assets, any legal right or beneficial interest therein. All the three aspects, but this is the corporate debtor. This issue also arose before the Honorable NCLT in the case of jet aircraft maintenance, wherein the RP and the COC had converted an asset as into non-core asset of office building, on which, in fact, one of the creditors had a secure encumbrance in charge to relinquish them and gave an NOC undertaking that it can be sold. And the purpose was to enhance the value of the corporate debtor by paying the balance sum to the aircraft owners, so that ownership of 11 planes could be taken, which would enhance the value of the corporate debtor. On this ground, HDFC Bank says out of 450 crores, 360 crores were given to them. So this raises a question. Now, in this context, now we have to, confining this issue, we have to go to the regulation 29 of CIRP regulations, which is an exception, which provides that any unencumbered asset can be disposed of. If we go to that regulation 29, sale of assets outside the ordinary course of business. The resolution professional may sell unencumbered assets of the corporate debtor other than the ordinary course of if he is of the opinion that such a sale is necessary for a better realization of value under the facts and circumstances of the case, provided that book value of assets, all assets sold during the CIRP period in aggregate under this sub-regulation shall not exceed 10% of the total claims admitted by the IRP. The sale of assets will have a affirmative vote of 66% of the POC, and the bona fide purchaser's right shall be protected. That is the case. So one exception, there is a provision in the, but now another issue comes here. If permission has been given for the better value realization, who will determine, and how because since it is approved by the 66% vote of the committee of creditors, so in that case, the commercial wisdom of the COC being supreme, there will not be any jurisdiction left. So it may be arbitrary. In this particular case, what happened ultimately? 11 aircraft were also sold. They were not made operational in that case. So whether it really added a value, that is also a case. And since the resolution in Honorable NCLT after discussing emphasizing that by the corporate debtor or other aspect did not give a conclusive finding ki only corporate debtor, they refer to the provisions of section 28 or other provisions of the IBC, where they say ki there is a leeway and authority to COC and the RP. It is not solely binding, that it is only binding on corporate debtor. But since in that case, the resolution plan has already been approved and implemented, which is still going under implementation due a lot of litigation is still persisting. But so they did not, they refrained from taking giving any cancelling the transaction ki it was violative of regulation 29, because one, it is an unencumbered asset, that's very clean, and in this case to make it unencumbered, an undertaking was taken by giving a sum, is fixing a sum towards as a consideration of getting this undertaking. So whether it amounts to alienate, and then comes clause 14(1)(c) may come. It will be an amount to recovery of claim by the one of the financial creditors. So that being apart, that situation being apart, the question comes: ki corporate debtor, or it applies only to corporate debtor, or it also applies on RP and COC. We are not touching the liquidator, RP and COC, because the moratorium has come into effect after the order of admission of the corporate debtor into CIRP, and the RP has become CEO, management has been suspended, board of director has become infructuous. So it is whether the RP has shifted into the shoes of the corporate debtor. That the corporate debtor is a corporate person, the company, but all for all, and they are also again we will go for that ownership agar disputed hai, so there are duties, taking control of assets of the, so many things are there. Interim finance is there, which says ki you can raise, IRP can raise, but to certain extent before the COC is formed, it should be not exceeding the value of such and such amount, and can security interest can be created. Interim finance can be section 28(1)(b) comes into play with 14(1)(b). 28(1)(b) may the COC, if we go for section 28(1)(b), notwithstanding anything contained in any other law, for the time being in force, the resolution professional during CIRP shall not take any of the following actions without the prior approval of the committee of creditors, namely, not raising interim finance in excess of the amount as may be decided, that is not create any security interest over the assets of the corporate debtor. That means ki section 28(1)(b) is also an exception to 14(1)(b). Corporate debtor is under control, and surprisingly, if you read the language of section 28(1) opening phrase, notwithstanding anything contained in any other law, that means ki IBC is excluded. Any law to any, there been any law, the other law. That means ki there is an apparent conflict in section 14(1)(b) and 28(1)(b). How to resolve it? That's the question. Because interim finance is different, and create any security. What is any security interest? So whether the moratorium should prevail, the provision of 14(1)(b) should prevail, or 28(1)(b) should prevail. But since it is a financial creditors centric regime, so obviously a view have been taken that committee of creditors, which is trying to resolve the insolvency, making it the corporate debtor, bringing the corporate debtor back on its feet, so they can take a decision. So for 18, so another exception is given and the exit window is given if the situation is granted. But my view is, another thing is, it cannot be restricted to corporate debtor only. There is another reason. If you see, read section 74(2), any creditor for violation of such provisions of section 14 can be fastened with the penalty. But if the section is 14(1) is not applicable, how a punishment can be given? So by logical inference, it is applicable on the intent of the legislature is to make it applicable on the creditors also. So it's not, but I don't know what finally happened, because that decision would not have been made to the would not have been subject to appeal before the Honorable Supreme Court. So hence that is a different story. So in any case, the bottom line was that the Honorable NCLT, in view of the things becoming infructuous because of resolution plan being implemented, a lot of water has flown in the Ganga. So they refrained from reversing the transaction. And no conclusion, but it is an issue which would need certainly a consideration of Honorable Supreme Court. What do we mean really by corporate debtor? But if we read 74(2) and 14 together, it becomes clear that once the creditor is included, RP obviously under other provisions of IBC Code of Conduct and other things, bona fide section 233, suppose is there, bona fide act, there may be separate provisions, and it is in any case the prior approval of COC. So 14(1)(b). Now this takes us to another interesting thing. We will note that somewhere in section 14(1)(b), the word assets has been used. When we go to section clause C and clause D, the word property has been used. So it has got, what is the intent? Asset is restrictive, properties in wider term. Section 320, subsection 27 defines the property. It includes so many things. B में तो ठीक है, beneficial interest and legal right covered है, but in this C there is a security interest. Again, section 331 will come into the play. Security interest definition जो है. Now 14(1)(c) restricts and now it is a very important provision, because this provision in essence is a standstill provision as far as the creditors, financial creditors are concerned, because the purpose of insolvency resolution or IBC would get defeated if they encash or they try to foreclose or recover or enforce their security interest. If they have got that, if they do not surrender it and make it available to all, sharing of all the assets in the proportion or whatever the resolution plan says. So if that, the basic purpose of CIRP would get defeated. So it is a standstill and on the actions of basically of creditors, financial creditors who have got the security interest in their favor. But in this, there has been instances where the section 331 itself says the performance bank guarantee will not be covered. So in case there is a performance bank guarantee which has been given by the any bank or any financial creditor, that can be encashed. And if some security is provided, that can be utilized, because the margin money given or the asset given for that purpose only restricted to performance bank guarantee can be done, because 331 does not cover performance bank guarantee in itself. Now we come to the 14(1)(d). 14(1)(d) it encompasses. There are the language we have to see. It's very important language of this section, and it has been interpreted by the Honorable Supreme Court in the case of Rajendra Kumar Gupta. The recovery of any property by an owner or lessor, where such property is occupied by or in the possession of the corporate debtor. So there are two aspects mainly. This section doesn't cover within its ambit the assets of the corporate debtor, because the recovery of any property by an owner or lessor, the property belongs to either its owner or the lessor. So any assets of such nature are not the assets of the corporate debtor at the very outset. But the recovery thereof is prohibited. You can't recover. The other condition is very important condition is occupied by or in the possession of the corporate debtor. Both these words in the context of this section has been extensively dealt in that decision. And what the Honorable Supreme Court has opined that it means the occupation or possession means the physical possession, not the constructive possession or constructive occupation. It must be actually in the then only it can be recovered from that. So this takes us to another point, which is very interesting, how there are decisions. 18(1)(f), taking control and custody of corporate debtors, assets of the corporate debtor. But explanation there too says assets held in trust or under contractual arrangement shall not be the assets of the corporate debtor. So now again comes 14(1)(d), if the assets, but where shall not be constituted. The Honorable Supreme Court in this very case has observed that in the context of section 14(1)(d), there is no need to refer to either section 18 or 36 of IBC, because there is a duty either of liquidator or the RP to deal with the assets owned by the corporate debtor or belonging to the corporate debtor. Here the assets are different, but this was not a specific issue in that case. These are the passing observations. As against this, there are decisions of the Honorable NCLT in the case of weather makers that 18(1)(f) explanation is an exception to 14(1)(d), and any asset which doesn't belong to the corporate debtor or held by him as trust or under contractual can be 14(1)(d) will not come into the way when it is recovered or it is to be handed over to the such owner or such person. But this is whether observations or the findings. So this situation needs to be reconciled because the people suffer. There is a case. I have dealt with a case. I am still dealing with that case. There is a corporate debtor, which one person, X Limited, they entered into a joint venture, holding 51% and 49% respectively. But that X Limited gave complete funding to the joint venture, which in turn gave to the CD, and they even provided margin money for the fixed deposits, and they are executing the contract. In essence, the corporate debtor is only a name lender, and there are provisions that whatever proceeds are received from the end client on the same day, it will have to be remitted to the corporate, the joint venture. But RP is not doing that. So that is an interesting issue. Let's see what it would be the outcome. So these the challenges and problems come. Achha, another thing is 14(1)(d) is applicable to both types of properties, whether movable or immovable. because the property has been defined in section 327 of the IBC. Now we will come to the explanation which has been added from 28/12/2019 as a fallout or as a measure of overcoming the difficulties posed by the decision of the Honorable Supreme Court in the case of embassy property developments. So what it says is that since there was no specific provision, and we can simultaneously we can take up the issue whether under writ jurisdiction of where writ jurisdiction either under 226 or 232, the moratorium provisions do not come in the way of exercise of those jurisdiction by the Honorable High Court or the Supreme Court, or even their appellate jurisdiction under Article 36 or 227, they do not come into the thing. So, this cannot be dealt with. But more particularly, we can with confidence say that they are the constitutional courts. Hence, unless some appeal is some order is appealable as an exercise of wrong exercise of jurisdiction, though jurisdiction exists, they will not intervene because the appellate procedure is prescribed. But when there is a lack of jurisdiction, they will entertain, and they are quite competent to pass an order under those articles of the Constitution of India. And moratorium cannot be a ground to say that they don't have that power, because we are the adjudicate authority itself is a creature of statute, which is by virtue of constitutional provisions. So it cannot be held so. It has been clarified in number of decisions that in these cases, the High Court and Supreme Court can exercise their jurisdiction under Article 226 and 32 of the Constitution of India, if it so warrant. Now coming to the explanation.
Yeah, after this explanation, sir, we'll also just take 2-3 questions.
Yes.
Yeah,
So I will cover
please.
all the things within 5 minutes. I will rush through so that everything is covered.
Yes, yes.
That we can have
Please,
questions.
please. Absolutely.
But then there are two conditions in this explanation. Number one, it should not be suspended or cannot be suspended or terminated on ground of insolvency. Number one condition is that if there exist other requirements or laws, as in the case of TCS, since it was found that it was not connected or arise only on ground of insolvency, there were other valid reasons. The Honorable Supreme Court did not intervene, did not reverse they say 65 subsection 5 clause C cannot be invoked in this situation, which they did in the Gujarat Urja Vikas Nigam case, because they found that in that case it was a case of the termination of the PPA solely on account of insolvency, on the ground of insolvency of the corporate debtor. So that is also in addition to section 14. Section 60 subsection 5 has also been judicially involved or activated to protect the interest of the corporate debtor. So that is one thing. And another condition is that they should pay the current dues of the such use, continuation of the use. That means if a money is said, the supplier of the goods or services cannot adjust it against the dues prior to commencement of CIR. There is very clear. This is explanation. Now, supply of essential goods or services to the corporate debtor as may be specified shall not be terminated or interrupted during moratorium period. This provision takes us to chapter 10, chapter 9, something of regulation 31 to 34 of CIRP regulations, where what would constitute essential supplies, everything is designed and how it will be deemed dealt with. And so many clauses are there. I am not going to, it's not that we can go each clause wise also, what it covers, what it does not cover. But in nutshell, this should not be a direct input to the output. And that is one thing is prescribed. And what does it say? That is chapter 9. Or it also includes 14(1)(d), the property which, or now the regulation 31A has also come. So these are the provisions which are says ki these will be treated as IRP costs and will be having a seniority above all other debt liabilities of the corporate debtor. These will have to be first met out. So that is related to supply of essential goods or services. But the question comes, the question remains, if there are no financial creditors, if there are no sufficient funds or assets, who will be paying it? Who will be contributing it? And because if there in UNCITRAL guidelines, there is a process, there is a provision for withdrawal of CIRP if the IRP cost cannot be met out. There are no proper funding. But no such provision exists here in our laws. So subsection 2A. Now this is different from both essential services, goods or services. This is critical. Consider the supply of goods or services critical to protect and preserve the value of the corporate debtor and manage the operation of the such corporate debtor as a going concern. Then such supply shall not be interrupted or suspended. And same provisions, charges for the supply during the moratorium period must be paid. But here is the responsibility is on the corporate RP of the corporate debtor. His view. No, there are no other guidelines prescribed ki what would constitute critical services, what would constitute critical supplies. But except the discretion has been given to the RP, critical to the protect. So there is a gray area. There may be different situations, different interpretations. That printing wala, the case may come whether essential supplies are different and these supplies are different, and this subsection 2A would be covered otherwise under clause C of section 5 subsection 13 of IBC to run the business and protect the assets. So it may also be a IRP cost in that sense, but there is a specific, though it may be IRP cost, but there is a specific provision made here to make the payment of current dues. Generally, the current dues are also formed either if there are interim finance or some funds are available, then those are to be paid, IRP costs to be paid out of those to run the affairs. But that is another thing. Subsection 3 is an exception to that. It will not apply to personal guarantors. Surety of a corporate debtor that has been statutorily recognized, which was said by the Honorable Supreme Court in the case of SBI versus Krishnan, first time. So that has been statutorily called.
That was one of the
Amendment
first major judgment that had come in this.
on the personal guarantee. And the clause A has been amended. Earlier it was restricted only to financial sector regulator. Now any other authority has been come and the transactions notified. And in pursuance of exercise of power under this section 14(3)(a), on 17 June 2023, certain transactions relating to hydrocarbon sectors, production and sharing arrangements have been kept out of the moratorium. Those can be taken, modified or cancelled or terminated, so that the oil production in the larger interest of the country, oil production, does not suffer if the corporate debtor is not in a position to make the exploration and production of the oil because of its insolvency. So this is an exception which has been actually materialized, notification. This one. Then 14(4), we have another one aspect on 14(4) remained, which we have to see, that it applies to completion of CIRP, or proviso provides that either on passing of the order of section 31(1) or 33 of the IBC. But there is another provision where the CIRP can terminate, that is contained in section 12A, where the withdrawal of the CIRP can happen with the on the conditions met as provided therein read with regulation 30 capital A of the CIRP regulations. So in that situation, though there is no specific provision made in 14.4 taking care of provisions of section 12A, the implication is the same. Since the CIRP itself is withdrawn, so there cannot be any necessity for moratorium. So it automatically gets vacated on withdrawal. But there is no specific provision covered in IBC to take care of this situation, to make it specifically on withdrawal of CIRP, moratorium shall cease to have effect. That is one thing. Generally, it is moratorium is temporary, as we know the time bound coinciding with either liquidation or CIRP. But Section 10A is an exception. It is permanent. Any default occurring in that period, a specified period, for that default, there can never be a CIRP proceedings. Section 10A, due to COVID.
Yes, right. And a very
So-
important judgment has come with regard to 10A very recently, which I would like to just update my esteemed colleagues here, that the interest portion will also not go through the moratorium phase. So 10A
Yes.
period interest can be calculated if a Section 7 application, or for that matter, a Section 9 application or 10 application is not so vital, but 7 and 9 application, if it is made, and if that period of 10A has gone by, even then you will be able to add interest, penal interest, etc. for that 10A period too. So a recent judgment had come.
Whether the Supreme Court,
No, no, sir. It's the NCLT judgment.
NCLT, na? So it has to test the water of higher judicial wisdom.
That's true. I understand.
So that is so these are in nutshell the
Yes.
overall scenario relating to 14, 13, 15, read with regulation 29, which is there. So in general, these are the things. If any queries are there, I will try to address
Yes, yes.
with the help of other colleagues who are
Thank you so
present
much.
here.
Thank you so much. It was very, very extensive deliberation that you made. And I think the more importance was, without a PowerPoint, our apt attention was there on the words that was coming out from your mouth. And therefore, the attention span was extremely good. I'm sure all the participants have actually also heard with rapt attention. And there are one or two questions which I would kindly take it with you. That somebody was asking Mr. Anuj that what would happen to the commercial rights of the lessors in the Go Air insolvency saga in view of the moratorium when they cannot recover. So what is it
That
with
is
regard to lessors' rights?
that is where they cannot recover the property. 14(1)D comes into that. But if the property is there, the lease pay hai, then either explanation, sorry, 14(2)A will come. For the current dues till the moratorium exists, they will get paid. For the dues prior to CIRP, those will be treated as operational debt and will be treated as per the provisions of resolution plan.
Right.
That is the only way out.
Thank you, sir. There's another question which says that bonus was never paid in the past, which means before the company had gone into insolvency, bonus was not paid. But now when the company is into insolvency, because of the lack of funds, the RP is not able to pay the bonus, etc., because there's no fund. But the labor officer is issuing notices to the RP, asking for explanations, and of course, also mandating that labor laws needs to be followed. So how to really go about this? Because when you're struggling
Generally, the PF, gratuity, and other things which have been statutory, that is a bonus. We will have to go through. I have not gone through the level of provision, but bonus liability is an operational debt prior to that. It includes the dues of the employees also. Bonus is not a part of their salary in that sense. It is distinguishable because as compared to employees' contribution or employer contribution towards it is more linked with their salary or employees' contribution in more so. Bonus is a ex gratia payment which is given. Minimum payment is to be given if it has been provided under the books of account in the books of account of respective years but not paid. So first of all, the SSE must have suffered under section 43B. They must not have been allowed the deduction, and that is a different aspect. But to see that as far as my understanding goes, it cannot be paid. It cannot be paid. It is just like to be treated outstanding salary. And in case of liquidation, Section 53 waterfall mechanism will come into play. To this
Yes.
extent, because this also implies dues on that. But the resolution professional, now Section 32E comes into play. It should, if which says ki compliance with any law, the resolution plan will not be non-compliant if the law. So in that case, we have to see that aspect. Ki if it is to be complied mandatorily, otherwise the resolution plan would become non-compliant under Section 32. So from that perspective, we have to see the provisions of law. And if it is mandatory to comply with that, so the resolution, the proposed resolution applicant will have to make the provision for that in their resolution plan. Mandatorily.
Thank you, sir.
Otherwise,
yes. And yes, and gentlemen, you can actually also approach your COC because this is a CIRP cost. A running cost is a CIRP cost. You can approach your COC to actually contribute that money in the proportion of their voting rights, at least during the insolvency process. Whatever dues are coming off the bonus during the insolvency process, if the money is not there, you have to reach out to the COC.
That is, of course,
Absolutely.
that will form part of CIRP cost, and that has to be paid in any case. So on the top priority. Current dues of salary also. Current dues of salary also during the corporate debtor going under CIRP process, moratorium period, that will have to be paid.
Absolutely. So, my esteemed participants, from IBC Laws, which you know is a very, very research-oriented database which they have created and which highly works on technology too. One search in keyword actually enables you lot of pop-ups which actually talks about the subject and the issue that you have in hand. Today, from IBC Laws, me and the team has put together efforts to bring out all the moratorium related case laws in this 50-page document. I'll share this document with all of you. Gupta ji, I think if you can just नहीं आपको नहीं विकी गुप्ता जी ऐसे आप कहीं से आवाज आ रही है thank you. So we have put together this document, and which I must say that also covers a lot of these judgments which Mr. V.K. Gupta sir was actually talking about. So it has the judgments of course, what has emanated from Swiss Ribbons. He also spoke about the Sundaresh Bhatt judgment in the ABG shipyard matter. And then this entire document has actually analyzed what has come through the ordinance of 2019, which then became the Amendment Act of 2020. The Ramakrishnan case has also been dissected. What is the meaning of the word moratorium and how the word all is so important? If you recollect what Gupta sir said, that against the corporate debtor, whereas when the company is in liquidation, it is for and against both. So he aptly and rightly brought out the fine nuances that the language carries in terms of moratorium. And as we all understand, a lot of times in interpretation, and has to be read as or, and or has to be read as an and. So all that nuances also has been brought out by Sir. It also talks about what are the proceedings and how the word proceedings is an inclusive word that has been used in the law. Then it talks about how the proceedings pending before all courts automatically stop, and the RP is not required to really take any further step. Sometimes, in the courts, when dates come as a RP, I suggest, and I also tell all of you here, the young generation, at least who's attending the seminar today, that you must go to the court and tell the court that, Lordship, this is under moratorium. You should produce the order of admission of CIRP and ask for a sine die adjournment. And because otherwise it actually gets into a very ugly face. So it's very important.
That is the responsibility of IRP and RP. as per the
Right.
provisions of IBC, they
Absolutely.
are bound to intimate every authority for that
Yes,
matter.
right. So please, we must do that. Don't think that moratorium is here. हमारा तो कोई कुछ हो कर नहीं सकता है. I think that's not a very healthy approach. Then it talks about initiation of CIRP against a subsidiary of a corporate debtor will of course not be hit by moratorium.
Will not be hit by that.
Absolutely. And we've laid out all the judgments. If you can see, we've talked about judgments like Axis versus Alok, and we've also given the citations. If you can see here, the citations are given. So any amount received during the CIRP when the moratorium is in force is the asset of the corporate debtor. So a lot of times it happens that the money has been it's under a stay or under an attachment in any bank account, and when the RP comes in, it takes all efforts to bring that money into the corporate debtor's bank account. So the law is very well settled by judgments also that it will be treated as the asset of the corporate debtor, and nobody can actually use that money apart from the RP to the common account. Yes, sir. Then proceedings which are in the benefit of the corporate debtor can still continue as Lordship VK Gupta sir has mentioned. So we are so used to call him Lordship that sir or Mr. It just doesn't come out. Then it says that High Court ought not to have proceeded with the auction of the property once the proceedings under the IBC had commenced and an order declaring moratorium was passed.
Yes.
VK Gupta sir has also rightly and aptly pointed out that moratorium will only get over with the order of approval of the resolution plan or the order of liquidation. So for example, if 180 days has expired or 270 days has expired, your moratorium also doesn't expire automatically. It will expire with the order of either approval of the resolution plan or with the approval of liquidation order. Then it talks about impact on proceedings. This was a very sought after topic when it was just in the beginning of the IBC. Now it is settled that arbitration can go on, but if it is against the corporate debtor, that cannot be proceeded with. But if it is in favor of the corporate debtor, the benefit can be taken by the corporate debtor. It's very settled now. So if you see this document actually, and I'll also take the liberty to share this document with VK Gupta sir for his read and suggestions also.
Yeah, it's a very elaborate, and it takes care of so many matters which have arisen, and it is a compilation of growth of law on the subject of moratorium.
Absolutely, sir. And we will also request you to please honor us by taking this IBC Laws subscription, if at all you're just not having one now. In the
I don't have it for the moment. I will.
Sir, it'll be an honor for us. So then it also says that the adjudicating authority has no jurisdiction to set aside the order passed by the Indian Council of Arbitration. Once the resolution plan is approved, the arbitral proceeding may continue. Okay, so moratorium is not forever. So that is what it brings out here in the case of.
That is what I told. But in that case, the issue of tricky issue of adjustment of counterclaim
that's
or
also
other thing that will come.
Yes, sir. And we've also brought that out. You rightly mentioned, sir. So this Negotiable Instruments Act impact, people were really worried. We had so many questions, but that's also settled now. And sir has aptly also brought it out. Then we spoke about impact on moratorium on criminal proceedings and prevention of money laundering act. So a very recent, why we've put if you see a strike through. So there was some as sir was also mentioning that it has to test the waters of the higher courts. But now in NCLT, the Varsana Ispat matter is relevantly bringing out that if it relates to the
will not be covered under moratorium. That is very clear.
Yes. So I think that's the logic of the law also. So here we brought out all the other judgments relating to this. So this document is we really took a lot of efforts to, bring this in front of all of you. So that your time is also worth the spend. And we really requested Gupta sir for this so much time that he has given to not only bring it out today, but also the preparatory stage. It's when we come to you, it actually helps us because then we read a lot and we are also enriched. That is why it is said that knowledge is most enhanced is given. Yes. So impact on existing contracts and termination of the contracts, where it importantly said that statutory right of a financial institution to proceed under the SARFAESI Act remain suspended for a limited period. Then
Limited
it also went on to say in further few judgments that when the moratorium ends, and say, for example, the company is going for liquidation, the financial institutions, or for that matter, if any other lender, will have the right to actually add the interest, the penal interest, damages, etc., the way they do it, when a fresh claim is updated or filed in the liquidation process. So that clarity has also come, which was not there previously. Yes, sir. So what Lordship was mentioning before.
Because 33(5) doesn't bar the continuation of the proceedings.
Yes, sir. Right, sir. So what sir was also mentioning about the counterclaim, so that has also been answered. So therefore, we would also talk about the impact of properties which has been given out on lease and rent. Now that's also very clear. Somewhere or the other, it has. This is the line which I really want all of you to see, that what is material is that the property should be occupied by the corporate debtor, which is interpreted as actual physical occupation of the property and not the right or interest created. Because otherwise it would have been a havoc on the contracts. So I think this fine line of difference is what, as professionals, we need to really read when we go through a document. Then whether the amount of rent due to the landlord has prejudicially affected on account of moratorium, the answer is no. So we'll have to really go through it to understand what is prejudicially affected.
But prior to commencement of CIRP, it will
Yes, sir,
certainly fall within the definition of operational debt.
Absolutely.
And thereafter covered under IRP cost.
Yes. So whether a property which is not owned shall come within the ambit of moratorium has also been answered. Then the property not owned by the CD do not fall within the ambit of moratorium. Right? So it is a 50-page document and we are still at page 16. So what we will do is we will share this document with our esteemed participants who have joined us in this workshop today. There are 86 participants now, and in the beginning we had about 128. We'll try and see if you have already given your email ID. We'll request our offices to send this document to you. I will just ask any one of you who still have any queries, may kindly raise it. Just raise your hand and we'll unmute you, or we'll take it through. Yeah. Yes, Mr. Thakur, all of you are writing your email ID, but when you actually got into this seminar, you already have given your email ID. So no worries, we'll take it from there. Thank you, Mr. Gupta. That had really been a very elaborate session, I must say that. And it actually makes a lot of sense when we hear it from you, because you've been into the thick and thin of it. We look at it from another angle as a professional or as an RP. And when you sit in that chair, you look at it from a gamut of holistic approach. It's not only justice which needs to be done, but justice needs to be seen to be done. So you have always balanced that tight rope. So it's always a pleasure to hear you, sir.
That's great of you. And thank you, Gupta ji, SM Gupta sahab. It has been a pleasure to see you after a long time. Unfortunately, I have not been to Kolkata after my retirement. And
आप आइए sir, आप आइए. You are most welcome.
I will surely come. Organize some webinar or conference. I will come.
We will do that.
We will do that.
Thank you.
I will surely. People of Kolkata are very lovely, very beautiful, good natured. So it is always
आपकी मेहरबानी है sir.
And it has been a good interaction always. And I thank to all participants. And if I have missed out some points, I regret that. But in the short time, I try to cover the main points of the interpretation of what the words have been used. And there can be some specific instances come to the same section, same word has got a different dimension when there a different issue comes. So it always growth of law happens in that way only. But it has been a great journey. Thank you, Mamta ji.
Thank you.
Ratio disidentity when done. Thank you, sir. Thank you so much. Thank you, Omkar ji, for giving us this IBC.
Omkar ji, you are doing a great job. Great job. Please continue with that, and anything wherever I could be of any use, it would be my privilege to associate. Looking forward to meet you and have an interaction.